Hey guys, attorney Anthony Bandiero here, bringing you the Roadside Chat. All right, this question comes from an officer in Idaho, and he basically says, the officer is an SRO, is animated pornography illegal? Okay, so let's kind of go through this, right? So the officer here is saying, okay, look, I'm an SRO in Idaho. We have a student that was looking at animated porn on a school computer, right? Now the school handled the issue on their side, but the officer is wondering about the criminality of these issues. Like, can we actually criminalize animated pornography, right? Because there is no victim, right? There's not a real person on the other end of this that was actually victimized, like traditional child porn. He says he spoke with the juvenile prosecutor and the supervisor, and we're kind of at a loss, right? We're not sure how to look at this. If it's drawn versus real seems to be the hangup, right? But the officer worries about the future because these images look so real. And if children are being depicted, that's an issue. Who would the victim be? Okay. Wow. What a great question, because this is something that law enforcement officers around the country are going to face. So I'm going to give you a couple of pointers about how I view these issues. I'm not going to give you, I can't give you legal advice for Idaho because I'm not an Idaho attorney. And I have not looked at what their law says, but I'm going to give you two laws. One is from the California, that's very, in my opinion, very common about how these laws are written. And I'm going to give you federal law. Okay, so let me give you the penal code from California first. Again, this is a very common way of addressing these issues at the state level. California Penal Code Section 311.1 makes it a crime to make, distribute, reproduce, or possess any representation of information, data, or image that contains or incorporates in any manner any film or film strip, any obscene matter, knowing that the matter depicts a person under the age of 18 years personally engaging in or personally simulating sexual conduct. Okay. So would animated porn, right? Child porn violate this law? And the answer is no. Because as a case called People versus Gerber, 196 Cal App 4th 368 in 2011 states that it would appear that a real child must have been used in the production and actually engaged in or simulated the sexual conduct depicted. So even though it might be animated, you're still going to have to prove that there's a real kid behind the scenes somehow, being the one that it's based off of this child, right? Somehow being involved in the act. So that's where the problems come in with what the officer is dealing with on the school. Now, again, the officer obviously, there's all kinds of violations of school conduct, with this. But the officer's not asking about the school rules. You can't have any pornography, right? Adult or child at school, right? Looking at it and possessing it and so forth. I'm sure there's all kinds of rules, but that's not going to necessarily be a criminal issue. So if we're looking to charge a child criminally with pornography, well, A, is involving a child, and B, does your law require a real child be used? Most states, in my opinion, my experience, say yes. But then we have the federal law. So the Congress passed the PROTECT Act in 2003, which outlaws anything that contains the visual depiction of any kind, including a drawing, cartoon, sculpture, or painting that depicts a minor engaging in sexually explicit conduct and is obscene, or depicts an image that is or appears to be of a minor engaging in sexual intercourse. and lacks serious literary, artistic, political, or scientific value. Now, there was a Supreme Court case called Ashcroft versus Free Speech Coalition, 535 U.S. 234, 2002, where it claimed that a prior law, right, prior to the Protect Act, was overbroad and violated the First Amendment, especially involving animated, right, arts, right, animated arts. So the Protect Act was supposed to fix those unconstitutional infirmities. But the way to look at this is that, okay, if you simply have animated child porn, you don't have a child porn violation. What you have is obscene speech. See, the two different things, right? Because we don't have the victim here. Again, most child porn laws, even at the federal level, require a victim that is underage. But what the Protect Act is likely also going after is the obscenity part of it, right? You don't necessarily need a victim when you have obscene speech like this. So the First Amendment does not protect obscene speech. That is a case called Miller versus California, 413 U.S. 15, 1973. Therefore, the images depicting child sex acts that do not involve real children can still violate the Federal Protect Act if the material is considered obscene. This was affirmed in a Ninth Circuit case called U.S. versus Shells, 546 F3D 965, Ninth Circuit 2008, where the court said the fact that the statute does not require that an actual minor exists is immaterial because it's the obscenity statute. It's an obscenity statute and not a child pornography statute. Okay, in summary, I'm sure it violates a school code. So you're gonna, no matter what, looking at some kind of, pornography, adult or child on school property can be handled that way. As far as criminally, look at your state law. Does it require an actual child? Usually they do. If the answer is yes, then animated child porn is not going to be, enforceable, right, under state law. Now, unless it leaves it out. However, you could have, if you have, again, you're going to use your good discretion here. I mean, there are some situations where I think they're a little unfortunate where minors have a dating relationship and they share videos back and forth or pictures, and sometimes they're getting the boyfriend, whatever. Again, he's a minor too. Let's say he's 17 and the girlfriend's 16, whatever, and he's getting charged with a sex crime because he has pictures of his girlfriend on his phone. I personally I hope that cops are using very good discretion when they're charging these cases, and I think they usually are. The boyfriend is sharing the pictures, maybe he's blackmailing the girlfriend, things like that. Yeah, you're going to fry for that. So, but if you have a kid with animated porn and it's obscene, right? Especially it looks real, it looks like a kid, that is not legal speech. And you can bring that to a federal prosecutor to see if they want to take the case, right? So I think that's my best advice for now, from what I know about this subject. I hope it helps. Before you leave, do me a favor, smash that like button, hit subscribe, share with your friends. That helps me get the word out so that cops are making good case law. That's my goal here. I want you to get it right every single time. Until next time, my friends. Until next time, my friends, stay safe. Thank you.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.